The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. Welcome to this special session of the Iowa Supreme Court held in Newton at the Newton High School. We have one case will be submitted this evening. That case is Peg Hutchison and others versus Douglas Shull and others. Mr. Foley, you may present your argument.
Thank you, Justice Cady, Counsel. May it please the Court. On April 18th, 2014, the Board of Supervisors for Warren County met and decided the fate of 12 individuals. Mike Carroll, my assistant counsel, and I represent 6 of them. On that day, 12 positions were eliminated from the county's workforce. 2 resolutions were passed, and not a bit of discussion occurred with respect to the pros and cons of that decision, at least among the supervisors. Prior to April 18th, the decision to reduce these positions had been completely implemented. On March 25th, 4 of my clients were told that their positions were being eliminated. They were to pack their stuff and leave the county. The next day, March 26th, 2 of my clients were told their positions were eliminated. They were to pack their stuff and leave the county. The trial we had on this matter established that this decision was not made in an ordinary way. It was made through what I referred to at the trial level as shuttle decision making. What happened was one of the supervisors, Douglas Shull, would meet with supervisor or city administrator, county administrator, Ms. Furler, and they would flesh out this reorganization. Then Ms. Furler would go to the other 2 supervisors, Mr. Wilson and Mr. Yordy, and get their approval on various aspects of.
Let me ask this question. One of the city council persons meeting with the county administrator is not a quorum.
I agree. I agree. You need 2 supervisors.
Because of 3, you need 2 supervisors.
Correct. I agree. But that doesn't, in the statute definition of a meeting, actually talks of a majority, which would be a quorum.
In this case, it's a quorum, yeah.
In this case, correct. So what would happen, though, is they would iron out all the details of this plan. And this went on through February and March of 2014. And decisions were made through this system, and it's clear.
The statute says a meeting is a gathering of a majority of the decision makers, basically. How is this shuttle diplomacy a gathering?
It is a gathering because a gathering is defined, and even appellants put this, appellees put this in their brief, as a coming together of things or persons. And what happened here is you had a coming together of the ideas and the concepts underlying this reorganization.
Well, but the term gathering ordinarily implies some kind of physical contact. You have gatherings at church, you have gatherings at school, you have gatherings on a courthouse square, gatherings for Thanksgiving. But ordinarily, you don't think of gathering ideas. I mean, if you're a poet or some kind of academic wanting to have a clever phrase, but the gathering of ideas doesn't seem to be an ordinary use of the language. does it?
Well, it's not only a gathering of ideas, but it was actually a gathering of these individuals. And they used Furler as a conduit or their agent.
But the statute is pretty clear. It has to be a gathering in person, which they weren't in person,
Well, it actually can be through electronic means.
or electronic means, but the city administrator is not an electronic means.
But it also says, right after that, formally or informally. So for this court, what this court has to decide is whether or not what the legislature intended when it said informally. Did it
Did
intend?
we already decide that in the Dubuque Telegraph-Herald case? And for you to win, do we have to overrule our own precedent from 1980?
One, I think that is dicta in that case. Two, there are, I think, maybe 3 sentences devoted to that issue where the court rejected the argument of that was an informal gathering and said, referred to temporal proximity and said that implicit in that you needed temporal proximity. And that was what hung up Judge Gunderson. But here I think you do have temporal proximity because these meetings are occurring back to back to back to back, and you don't have, and they have to occur that way.
Counsel, in that regard, you mentioned the intent of the legislature, and you're obviously arguing that in using the word gathering in the statute, the legislature didn't presuppose that these would be in-person meetings of a majority of the members of the body. What are we to make of the fact that there was proposed legislation in 2005 that would have, I think, come closer to the interpretation of the statute that you're advancing, but it wasn't adopted by the legislature? Is that, should we view that as a significant indicator of what the legislature's intent is in using the word gathering?
No, I don't think so. For one, it was not voted on, as I look at the legislative history of that act. It was there, but I don't believe it was ever voted on. And this court stated in State v. Nail that amendment to statute withdrawn prior to vote is not dispositive or even illustrative of the legislature's intent regarding a civil penalty statute, which was in that case at issue. And it cited Justice Scalia in the United States Supreme Court cases, and what he said is that he was warning courts risk ignoring rudimentary principles of political science, drawing any conclusions regarding legislative intent from the failure to enact legislation, and that's your case, State v. Nail, 743 Northwestern 2nd, 535. So I think the court shouldn't draw any inference from that, because as we argued in the brief, there can be a lot of reasons why a particular proposal doesn't, or proposed bill doesn't become law.
Should we draw any inference on the fact that when we pronounced in 1980 that the meeting, they have to be a majority together, the legislature never acted to overrule that decision? Have they acquiesced in that interpretation?
Well, and you're referring to the Dubuque Herald
I am.
case. Justice, to me, that's a whole different case. That case, if I remember the facts correctly, you had individual council members interviewing applicants for the city manager position. There was no evidence at all that that was coordinated. There was no evidence of a courier who went back and forth between each of them to make a selection before they went into an open meeting. Under those circumstances, to this day, had that happened here, you wouldn't have a meeting. But it went beyond that. And the troublesome thing about this case is you have Judge Gunderson concluding that there's deliberations here. You are not just receiving information. You are deliberating. And actually, Judge Gunderson held that you are making decisions. This was done. This was decided before a word of it ever was brought up to the public. And that's what distinguishes this case.
Mr. Foley, aren't there two separate requirements for a meeting in the statute? One is the gathering, and the second is the deliberation or action.
What's interesting, the way the statute is written is a gathering of a majority of members where deliberation occurs. So it's not an and conjunction there. But you would have to have both. But as we argued in our brief, Judge Gunderson found that there was not just deliberation in the sense of individuals thinking about things, but that there was group deliberation. This body decided things as a group. They deliberated as a group. You cannot do that as a matter, as I said in the brief, of logic or law without coming together. How can a group make a decision if it doesn't come together? And here we have one, Judge Gunderson's finding that occurred, and two, everything was done on March 25th and 26th. When I talked to Supervisor Shull about that, and I said to him, on the 18th, there was no way to get this, and I didn't use these words, but toothpaste back in the tube, and he agreed with me. We were too far down the road. This was an implemented decision. If this is not, if that courier system can be used to avoid the requirements of the open meetings law, anything goes. You're going to have fewer, you're going to have this happening over and over again. Decisions will be made behind the scenes, and then they will be, in effect, ratified during a public meeting without any discussion whatsoever.
Well, so does that mean that we have a 3-member board of supervisors and there's some administrative staff? Whenever a member of the board of supervisors communicates with an administrative staff person about a topic, and that administrative staff person then talks to supervisor number 2 and gets some feedback from supervisor number 2 of some kind, does that trigger the red flag for a gathering under the statute?
No.
In your view?
No, it does not.
And why not?
Because you don't have the decision being made. You don't have the deliberation where they are going back and forth on policy decisions. Let me give you a good example. For example, the board secretary position was originally in the mix for being eliminated. Supervisor Shull, the board secretary, reported directly to him. He didn't want that position to be eliminated. He said that to Furler. Furler went to Yorty and went to Wilson and told them that. At that point, they said, no, we have to treat everyone the same. Tell Supervisor Shull that we need to have that position eliminated. Furler goes back, tells her that. He then says, okay, and he told me in his testimony that he struck a compromise at that point. If that's not group deliberation, if that shouldn't be done in the public, well, I don't know what will.
Yeah, I understand very well, I think, your suggestion that they're trying to skirt the open meetings law.
Not just a suggestion, they told me that.
All right. Well, but that doesn't make it a violation necessarily unless you meet the statutory requirements. You don't disagree with that, of course.
No.
And then the question is, did they really gather for deliberation?
Judge Gunderson, as a matter of fact, found they did. She found not only, she didn't use the word gather, but she found not only that they deliberated, but that they reached decisions. She said that...
deliberate contemporaneously, I don't think. Correct me if I'm wrong.
Pardon?
They didn't deliberate contemporaneously.
No, well, the system would not allow that. Yeah, but they didn't need to. I mean, the key piece here is you have a reorganization of the entire workforce. You have, it wasn't just...
Yeah, but the outcome's not important. If let's assume they deliberated through proxy, or as I think there's a amicus brief filed through agency, okay? Let's assume that there's substantial evidence to support it, because that's a substantial evidence question. You still have to get the gathering. And,
well...
And that is what the district court found didn't exist under the interpretation of the law, and under what interpretation, and informal and formally, I don't think modifies gathering. I think it modifies something else. But under what interpretation of the law do you get that they gathered?
Well, if you look at the construction of the wording of the definition of meeting, informal or formal then either modifies gathering or it modifies electronic means. I've never heard of informal electronic means. I have heard of informal gatherings. And there's ambiguity here. So the court should also look at the first section of the act, which says you need to interpret this in a spirit of openness, or words to that effect. And to me, what the legislature was attempting to do there was to say, you know, we can't think of all the ways you're going to try to get around this, but if you're deliberating as a body and you're gathering thoughts and ideas to make a decision, and you're doing that formally or informally, you can't do that, because the act has no meaning otherwise.
How can government run, and let me give you this hypothetical.
Sure.
Say one of a three-board supervisor has the idea that they shouldn't be plowing this street at this time. And the supervisor goes to the head of maintenance or somebody and says, you know, I don't think this is a good idea to plow this street. Now, the street may be in another supervisor's district, so the head of maintenance goes to the other supervisor and says, you know, Supervisor X says we shouldn't be plowing the street. What do you think of it? And he says, that's probably a good idea, that we shouldn't plow the street at this time. So supervisor, administrator reports back to the first supervisor, says, he agrees with us. He agrees with your idea. Is that deliberating?
Well, I'm a little hung up because the plowing the streets is kind of like a ministerial type function. I don't see it as a real policy issue.
Take anything you want. They talk about a policy.
Let's say you talk about a reorganization of the entire workforce.
Yeah.
And what I'm saying is that...
They tell one guy says it's a good idea, the other says it's a good idea, and they report back, Supervisor A says it's a good idea. So every time there's this discussion through an administrator, and that administrator talks to another supervisor on a three-board, under your interpretation, we have a meeting.
No, that's not true. Them discussing and talking about it is one thing. Them actually putting a mechanism in place to not only talk about it, but to decide the issues is something completely different. And that's where I think the line is drawn.
Well, let's say they decided to do whatever I said to do, plow the street or whatever. They made that decision. They deliberated, the two of them, and said, this is what we're going to do at our next meeting. How do you have a meeting together, though? That's...
Well, in this case, actually, if you had the two people talking about that together, you do have...
No, I'm saying through the administrator, though. I mean...
To me, if they're making a decision through that means, that is a meeting. Because what happens is all the discussions occur behind the scenes. And it's not just the discussions, and it's not like Appellees state in their brief that you're weighing options and kind of thinking esoterically about things. This is where actual decisions were made. And they told us, why didn't you do this? We asked, why didn't you do this in a public meeting? Because we didn't want to get the county all worked up. We didn't want them to know about this. We'd take some political heat. So we came up with this way to accomplish something that everyone acknowledges was a policy decision, everyone acknowledges was within their government authority, and everyone, including Judge Gunderson, acknowledged they decided and implemented before April 18th, 2012.
Mr.
If
Foley?
you can do that, meetings will be shams.
Mr. Foley, when do you assert the decision to reorganize was made?
Well, because they didn't follow the procedure, it's difficult to know when all of these informal gatherings took place. It had to have been made before March 25th or March 26th.
Okay, did that decision have any legal effect?
No, it's void.
Well, didn't they publicly gather on April 18th?
They did.
And they adopted two resolutions that incorporated the reorganization?
True.
And isn't that the time period in which the official decision was made? And up until that time, even if there was this shuttle diplomacy going on, that any one of the county board of supervisors could have changed their mind or voted differently or inconsistent with whatever the shuttle diplomacy was doing?
Well, that's why I asked Supervisor Shull. on April 18th, could you have voted no? Given you had already told 12 people to pack up their stuff and go home. You had already fingerprinted and ran through security outside contractors to do the maintenance. You had already hired an outside contractor to do the payroll, had been doing that since the 28th. Could that have been done? Could you practically have said no at that point? And he said, I don't think so, no. So here you not only have these deliberations, you're not only having a decision made, you have a decision implemented that cannot practically be reversed. We're not guessing here. We know the decision was made, and we know that their hands were tied on the 18th. They told me that.
Well,
And
they were
one-
tied, as you said, for practical purposes, they were tied. Their hands were tied, but any one of those supervisors could have walked out there in front of that public gathering and voted a different way.
It would need two, but yes.
Yeah.
That's, in theory, yes, that could
Okay.
have
All right,
happened.
thank you. You'll have rebuttal.
Thank you.
Mr. Smith, you may present your argument.
Thank you, Your Honor. May it please the Court. Counsel? My name is Patrick Smith. I represent the defendants and the appellees in this case, the Warren County Board of Supervisors and the supervisors individually, Doug Shull, Dean Yorty, and Steve Wilson. One of the important attributes of the Iowa Open Meetings Act is its simplicity and its clarity. It's easy for public officials to understand it, and it's relatively easy for them to follow it. The reason being is that it creates a bright line test about what is a meeting and what is not a meeting.
Can I interrupt you before you go further?
Yes.
The district court found that there were deliberations, and I think she based that on them talking, them drawing up the contracts, them doing all this stuff before they officially affirmed it. And I think that's a substantial evidence question. Is there any question in your mind that on our review of substantial evidence, there is or is not substantial evidence to support that?
Yeah, we're not contesting that issue, Your Honor. We're
Okay.
conceding that there's substantial evidence to support that finding.
So what we're looking at is whether there is a gathering as defined by the statute.
That's the issue in the case. Is there a gathering under the statute?
All right, so why isn't it a gathering? Words are chameleons. They assume color based on their context. And the context here is a open meeting statute that is designed to allow citizens to observe the operations of government. We all know what the preamble says, and we don't need to go into that in great detail. But it seems to me, on the facts, that the supervisors decided to try and deliberate outside of the public eye because they saw it as a controversial decision. I think that's virtually undisputed, but I want to give you an opportunity to correct me, of course. So they are trying to steer their ship around a statute that's plainly designed to encourage public observation of elected officials doing the public business. And that's where the term gathering appears in the statute. Don't we read the statute and trying to give life to the term gathering, don't we read the statute as a whole? And isn't the term gathering broad enough to include the assembly of ideas, the sequential gathering of people's attitudes and votes sufficient to defeat the main purpose of the public meetings law?
Well, Your Honor, we would propose that the first place, of course, you want to look for the definition of gathering to be the statute itself, and it's not defined in the statute. And so,
Isn't it ambiguous then?
well, based on this court's longstanding precedent, as you know, we would say that the word gathering is not ambiguous. If you look to the ordinary meaning from the dictionary, gathering, as Mr. Foley said, involves a collection of, or coming together of people or things. Now, what the appellees, or what the plaintiffs propose in this case goes well beyond that ordinary meaning of gathering. And in fact, they say it's not just a gathering of ideas, but a digesting of them and a molding into a consensus. That's what
But didn't they gather, I mean, in all practicality, didn't they gather the subjective views of the three supervisors and tie it together in a decision? I mean, isn't that what happened?
In some ways, that's true, Your Honor, but the evidence does show that the county administrator, this all started with a general charge. These supervisors all, as it turned out, were kind of on the same page, that they wanted to look at the workforce and look at ways to make government more efficient. Oh, I'm sorry, I can't hear. Sorry about that.
Well, following up on Justice Appel's question, what should we make of the legislature's use of the word informal in modifying gathering? Doesn't that suggest a legislative intent to really have a broad understanding of what gathering means?
It certainly, adding the term informal certainly makes it broader, but I would direct back to the Telegraph Herald versus City of Dubuque case. It happens to be, it's a 35-year-old case. It was decided October 15th of 1980, so just about 35 years old. And the Iowa Supreme Court recognized in that case that the meetings of the supervisors, that's not an informal gathering. The key question is, it's the bright line rule that I discussed right in my opening, is there a majority of the governing board present or not? That's the bright line test and the principle that the court established in Telegraph Herald versus the City of Dubuque.
If plaintiffs win this case, going forward, would supervisors have to worry about getting sued whenever they talk to a staff person outside of an official meeting and had some discussion that's later on might be second-guessed as something like this?
Your Honor, that's really what's at stake in this decision, is the ability of elected officials to communicate, particularly with employees, also with the public. A county like Warren County, at the time of this reorganization and reduction in force, had about 175 employees. It had 35 different departments and a $23 million budget. And to govern that entity, we had 3 elected board of supervisors who are part-time. They're not unpaid in Warren County, but it's essentially a part-time position. They're not paid that much. And to run the county on a day-to-day basis, they had department heads, including a county administrator, heads of budget. So there's all kinds of, and also they meet twice a month. So in order to conduct the business of Warren County, it's essential that people be able to communicate with the supervisors on a day-to-day basis or outside a public meeting, and
Well,
that can occur one-on-one.
I agree with that in part, and as I understand the facts, I mean, this was a significant action by the board. You would expect that board members would communicate with staff members about it, surely. Nothing unusual there. But what is unusual, though, then, is that the decision is made in public without any discussion among the board members. So it looks like what's going on is a little more than getting feedback and information and shadow boxing with staff, as you might do. I mean, if you're doing a major reorg, you might call some staff member in, kind of scratch your head and say, how do we do it this way, that way, what happens is, but, you know, kind of game it out or whatever. But what's so striking here is there's no deliberation at all when the board meets. So it seems like more than kind of accessing staff was going on here, more than, you know, kind of gathering information and shadow boxing and all the kind of stuff that I think ordinary elected officials would want to do. Does that change the nature of the case? Challenge my characterization,
Sure.
of course.
Your Honor, well-
But then ask me or tell me if that has any impact on the case.
Well, the challenge here is, and this is kind of goes back to the ability of the elected officials to operate. If you have the bright line rule, you either have a majority or you don't, then it's pretty easy to decide. Otherwise, in just about every case, we're going to be having these arguments. Well, what was communicated, does it really rise to a certain level or not?
Well, but we have that already. For the three-member Board of Supervisors, whenever two have a cup of coffee, you got a problem.
Well, there's no doubt there's a gathering when there's two. There's a gathering of a
but
majority.
the big doubt as to whether they deliberated or not.
That's right, and that's not the question here. Typically, that's what the cases involve. You might have a majority, and is there deliberation? Here, that's not the issue. It's simply, is there a gathering? And again, in our view, the Telegraph Herald case answers that question head on.
But other states have interpreted this language, and I don't think any of you folks cited it. But for example, in Georgia, it says, stating that a meeting is required to be open only when a quorum of governing body or its agents have gathered, though the statute defined meeting as a gathering of the quorum of the members of the governing body of an agency. I mean, there are cases that will say, in other states who have interpreted language with gathering and meeting, to say when you do it by proxy, when you have someone else appearing for you with the intent or purpose of avoiding the law, and I think this district court found you had the intent or purpose, and again, that's a substantial evidence question, but with the intent and purpose of avoiding the law, you can't have a meeting under the open meeting laws of those states. And it's not just one state. There's other states that hold that. So how do you answer that question?
Well, first, Your Honor, it's the district court, and this is interesting, actually found that there was no intent to violate the Open Meetings Act. The supervisors actually intended to comply with it.
Yeah, but the district court made the wrong finding because the statute says intent to disregard the purpose, not to violate the law. And I think it's pretty clear that Shull testified that he had the intent to avoid the open meeting law by doing this way. So it's a purpose, not purpose. It's not the law itself. There's a little change, and I think district court played words. But let's assume that's there. How do you get around these cases that hold when you have meetings by proxy? And I think the amicus brought it out, and in the plaintiff's brief down below, they talked about meeting through proxy. How do you answer that question? Because then you have proximity, then you have temporal, you have all the things we talked about in Dubuque, but through proxies. I mean, how do you answer that? How can we deal with that?
Well, the challenge, Your Honor, is, of course, every time you have that, you have to make the inquiry, and with the bright line rule, is there a majority or not, then you don't have to, as the court said in the Telegraph Herald case, and that's why we're proposing that that's the best test. The cases that involve these the serial meetings or the walking quorum, if you will, the cases that the plaintiffs rely upon here, particularly the one they rely upon most heavily and that the district court discussed in her opinion was the Esperanza case, which involves the Texas open meetings law. It was a federal court interpreting that law. Those situations are still factually distinct from what we have here because they involve, for example, the Esperanza case involved all the members of the San Antonio City Council. They deliberately, 4 of them met together, and then another came in and they realized
But
that...
I hate to interrupt you, but that's a rolling quorum, and we don't have a rolling quorum here because if 2 of you get together, you're done.
Right.
And you meet the statute. So I don't know how those rolling quorum cases are applicable to this fact situation.
With respect to the issue of temporal proximity as well, though, which you mentioned, Your Honor, what the evidence shows in this case that the discussions and the deliberations about this proposed reduction in force occurred over at least a 2-month period of time.
But if the administrator was representing Council Supervisor A, when he or she was talking to Supervisor B, you have the temporal and proximity. Now, it may have been some shuttle diplomacy. You saw what it took to get that agreement with Iran. That just doesn't happen right away. I mean, so when you use this shuttle diplomacy, I think you might, and I'm not sure, you might get the temporal and the Dubuque things, but I don't know if we should go there or not. And tell me why we shouldn't or should. I think you won't say should. Well, we shouldn't. When they use a proxy, consider it as the person there.
Well, it's possible, Your Honor, if using the proxy, however you characterize the meeting, that in some cases you might get the temporal proximity. What we propose here is the bright line rule because it's simple, it's easy to understand and it's easy to comply with.
Well, maybe, but one of the features that bothers me here is, if you are right, what are the most controversial decisions that the Board of Supervisors would make? Tax levies, employment decisions, law enforcement related matters, could be done without public discussion and just have this little arrangement that you've got here. I mean, in theory, if you are correct, doesn't it give a blueprint to a Board of Supervisors to take the most controversial and troublesome issues, all of them, and decide them without the ordinary public deliberation outside the public view?
Well, ultimately, there has to be some kind of public action.
Well, I know, and you had it here, but, so I guess we could have the tax increase and the curtains open up and the three come in and vote yes and go out, I suppose. But boy, doesn't it, it just kind of hows out the entire statute, potentially.
Well, so long as, again, the purpose of the public meetings law, as identified in the very first section, is to have the decisions that the government body makes are accessible and the rationale therefore. And so then, so long as those two requirements are met, and we contend they were in this case, the county administrator and the county's outside counsel made a presentation to the Board of Supervisors at the public meeting describing what was being proposed.
Well, Counsel, you described this as an accessible scenario for the public, but as a matter of fact in this case, we know that the deliberations about this reorganization of the county government was done outside a public meeting, so there was no opportunity during the time that the decisions were being considered and actually functionally made for input by the public. And then, when it came time for the meeting on April 18th, isn't it true that there was not even an opportunity for questions and discussion of that decision allowed?
That's true, Your Honor, and that's essentially a different question, is how the board conducts its meetings. And at this particular meeting, the board did not allow public questioning or public discussion, and there's no requirements in the Open Meetings Act that they ever have to do that. That's commonly done among city councils or boards of supervisors, that the public is allowed to comment, but it's not required by the law. And if a board wanted to, they would never have to allow the public to ask questions, so long as they hold a public meeting, take a public vote, and the basis for that decision is available to the public in the form of either the presentation to the board, which occurred here, or the documentation, that is the what we call the bonnet report, the outside consultant's report about the anticipated cost savings and alternatives to providing the maintenance services. So the requirements of the statute were satisfied. Not in the way that these plaintiffs wanted, obviously, but...
Well, that's kind of, I know you're out of time, Mr. Smith, but when you rose to come to the podium, you first began to talk about the clarity in the statute, and I agree that when you first read the statute, it does give a sense of clarity, and a lot of statutes do. But what often happens is you put those words then into a context of some facts and circumstances, and all of a sudden that clarity gets a little murky. But what is really clear under this law is its purpose, and its purpose is to promote openness in government. And I think that we all can understand why, if people from this community came in on April 18th, came to sit down and watch its government function in a public, open way and make a very big decision for a community, they went away disappointed because they didn't see that. So even if the language is clear as you say it is, but the public sees it in a way that's contrary to its purpose, how do we resolve that conflict between what I see as a clear purpose that was avoided here, whereas the actual language may not have been?
Certainly, there's a balance here that the statute's trying to strike between making sure the government decisions are accessible, and also at the same time, and this is what the Bright Line test recognizes, that's the principle in the Dubuque Herald case, or the Telegraph Herald case, that is, there's a practical necessity here of being able to run the government. And that's sometimes the tension that exists here. What we propose is that the Bright Line rule, that if there's not a majority, as there was not here, and so long as there is the public action taken at a meeting, it obviously isn't going to satisfy everybody, but it complies with the Act's purpose of making sure the government action is accessible to the public and the reasons therefore, and then the public has the opportunity, of course, at the ballot box and otherwise, to tell these supervisors how they feel about that decision.
Thank you.
Mr. Chief Justice, could I ask a question? Let me just give you a hypothetical. What if it had been, say, 3 houses next to each other, and you had Shull and Wilson and Yorty, one of them in each house, and then you had Furler just going back and forth as an intermediary to conduct the discussion as a courier like that. Is that okay under the statute?
Well, it's a more difficult question, Your Honor, but under the test we're proposing, it probably would be. And what we contend here is...
Why is that a gathering?
Well, what the gathering, the coming together of a group implies that there's going to be some contact among the members, whether that's in person or by phone or email. All those are direct contact. Now, anytime there's an intermediary, it's not necessarily the same as it is with direct contact. And those supervisors, as one of the justices noted, once it comes time for that public meeting and they show up to the meeting, they have the right to vote. It's their vote. And all these supervisors knew that. They testified about that. And they can vote however they see fit, and there's no way to predict for certain that their fellow supervisors who they thought agreed with them before they went to that meeting are actually going to vote that way. So what we propose is that the Telegraph Herald standard is the best one. It strikes the proper balance between openness and the ability of these local governments to run their operations. And we ask that you affirm the district court. Thank you.
Thank you, Mr. Smith. Rebuttal argument, Mr. Foley.
Thank you, Your Honor. The Dubuque Herald case held that a majority, you can't have a meeting unless you have a majority of the members, but it went on to say, so long as no decisions are made and no actions taken. And that's a very important caveat, because here a mechanism was set in place whereby a majority never came together in one room, the same place, but deliberations occurred and action, I would submit, was taken. And we know that because of what happened on March 25th and 26th. That was a decision implemented. There was nothing hypothetical about it. There was nothing, 12 people went home with their stuff under their arm. That's real. That's not hypothetical. That's not something you can reverse.
Well, I just want you to answer one question for me, I guess. Clearly, this doesn't meet the spirit of the intent of the statute here, and I don't think anybody would disagree with that, but it still requires meeting the definitions of whether we have a meeting or not. The county supervisors have conceded that there was deliberations, which to me equals decisions, but we still can't get over, or I'm not sure that I can still get over that threshold of actually having a meeting. Now, whether this is good government or not, that's up to everyone else to decide. Likewise, because these are elected officials, You do see this in city governments and county governments all the time, where you either limit public comments or don't allow them. So I'm not trying to make a judgment on that, but I'm still having a problem with finding, that this meets the definition of meetings and the concept of a coming together of our minds or ideas, and that equals a gathering isn't getting it there. So maybe you can help me a little bit further on that.
Sure, Your Honor. I think Justice Apple referred to this. Since the definition of meeting is not clear, it is ambiguous. What was intended by gathering? What was intended by informal? How do you read the two sentences or provisions of 22.2.2 together? How do you read the first sentence that talks about gathering, the second that says a gathering is okay, in essence, provided it's for ministerial functions and provided it's not done to avoid, not violate, avoid the purposes of the act? How do you read those provisions together? And our position is that the only way you can meaningfully read those provisions together is if a body, governmental body, deliberates as a group, either through gathering physically or through some informal mechanism, you have a meeting. Because if that's not the case, the purpose of the act is completely eviscerated.
Well, let's deal with this bright line argument a little bit. And as I understand it, it runs something like this. Members of Board of Supervisors, I mean, they have huge agendas and a lot of stuff going on. We have, school board members where the meetings go into, 2 in the morning and so forth. We have city councils with agendas that have 80 items on them and so forth and so on. So these public servants need to be able to look at a statute and kind of have a basic understanding of what's going on. I mean, they can't call a county attorney every 6 minutes to get a open meetings interpretation. So they look at the language that says a gathering of a majority of the governing body is, the definition of meeting. They look at it and say a gathering of a majority of the governing body. The simple answer is, well, it means what it says, a gathering of the majority. We don't have a gathering of the majority, that's fine. And the argument is that interpretation, kind of a simple interpretation, is a bright line rule that public officials can understand and abide by, and that your argument is, kind of arcane and nuanced, and you got to look at the entire act, you got to look at this, you got to look at that, you're going to fudge here and tinker there and come up with a result. So help us with that.
Well, there is a benefit to simplicity. There's a benefit to people for the reasons Justice Apple, you stated. There's also a benefit because it doesn't take a lot to get around it. It doesn't take a lot to evade the purposes of the act. And if this holds, if what happened here becomes permissible, nothing will occur in the public, particularly in counties where you have supervisors of, Board of Supervisors with 3 people. As you mentioned when asking Mr. Smith questions, tax issues, everything.
But let me interrupt for a second. But if you have a board of 3, how are they ever going to get business done except once a month or once every 2 months or once every 2 weeks, whatever they meet, in the boardroom? I mean, they're going to have to talk the nitpicks of everything, or they're going to have to say, well, we want to do this, come up with a plan, then they bring a plan back, and then you talk about, I don't like it, come back again, we'll talk about it again. I mean, there has to be some way, some balance between the county doing their business and the open meetings law, and I think that's what the legislature might have tried to strike here. So that's a problem the other way. I mean,
no, and I understand that, and that creates issues. But appellants in this case have no problem at all with people shadowboxing with employees or even among themselves, discussing ideas. What happened, that is not what happened here. And to their credit, the supervisors could have just told me that's what happened here. Or as the amicus points out in their brief, they could have just met in someone's basement over beer and hashed this all out, and no one would have been the wiser. But what they did is they created a mechanism to get around the law. And they deliberated. They made important policy decisions in the shadows, and the Act doesn't permit that. One case that's cited in this case is, it's from Nebraska, the City of Elkhorn case, and it dealt with advisory boards. And what the court said in that case, which I think was very telling, is, look, there's no evidence of all of this being done in secret. They talked about things, they made recommendations, but when they went to the board level, everything was discussed, everything happened out in the open, no decisions were made, there was no evidence of any decisions being made at the advisory level, so you don't have a violation. The exact opposite happened here, and in essence, the supervisors turned government on its head. And if that's allowed to stand, then very little will be discussed in public. Decisions made behind closed doors will be ratified, and as Justice Apple said, the curtains will part and people will leave. Thank you.
Thank you as well, Mr. Foley. The case of Peg, Hutchison, and others versus Douglas, Shull, and others is now then submitted to the court.